Good afternoon, everyone. My name is Rich Beckman. I am an attorney. Been an attorney for about 33 years. Most of that has been spent doing a lot of residential landlord-tenant litigation, mostly in rent control jurisdictions, which used to just be San Francisco and Berkeley, and then Oakland, and now everywhere. 2019, as most of you know, it became a statewide phenomenon. So, and then March of 2020, we had the great COVID event, and a bunch of laws were passed to protect tenants from the disruption that was accompanying that event on everybody. And many of those moratoria have been in place ever since. They have been dropping off as time's gone by, and Alameda County, Berkeley, and Oakland seem to be the last of the holdouts. So that's what we're going to talk about today. And this is just the topics: Alameda County's eviction moratorium. So we'll start there, and then we're going to go into the cities and changes to the landlord-tenant relationship past the moratorium. Talk about the requirements of the ex parte application, which I'll describe if that doesn't make much sense. And then the issue about back rent that accrued during the moratorium. So just a little background: California and Alameda County health emergencies ended as of February 28th. The end of the Alameda County moratorium or state of emergency triggered the termination of the countywide eviction moratorium. And I just want to throw a little bit out there that's not part of the written material here. Alameda County's moratorium applied to both incorporated and unincorporated parts of Alameda County. Now that was a pretty big move because, well, it also said that if there are cities themselves that have greater protections, then the city's provisions would apply. That's going to come into play a little bit later in the talk here. But the city of Alameda took issue with that part of the Alameda County. I'm sure everybody knows there's Alameda County and then the city of Alameda. The city of Alameda's own moratorium expired a year ago or more, and it is a property owner and a landlord itself. So it had tenants that were not paying the rent, and the city of Alameda believed that it should be able to proceed against those tenants without regard to the Alameda County moratorium. So when the city of Alameda went to the Alameda Superior Court, Department 511, Judge Kolakowski, the presiding judge in that unlawful detainer department in Hayward, and submitted a request for a summons to issue in the unlawful detainer case that it brought for non-payment of rent. Judge Kolakowski rejected that application because it didn't meet one of the 3 Alameda County exceptions, which was, well, basically 2. The eviction was based on a public health and safety threat, or it was an Ellis Act. And since the Alameda City Ordinance did not present either of those exceptions, that request for a summons was rejected. The city of Alameda filed a writ proceeding, and the first district held that it's kind of a shame because the city of Alameda filed a really persuasive brief arguing that the county's moratorium could not apply within the city limits of Alameda. And they did a great explanation on county emergency powers and news to me, but it was, I thought, a really well-written brief, and I was persuaded. I thought the first district might as well be persuaded. What they did was they took that classic, we're going to decide as little as we can route. They basically said that the judge in 511 needed to consider their application as a revision to current law, and therefore they kicked it back to her to reconsider her rejection of the summons based on the city's argument that the county moratorium did not apply. The first district could have actually addressed the question that was before, which was, does this moratorium apply in the city jurisdictions? But again, they sort of took that less is more route. When faced with the renewed application at Judge Kolakowski at 511, she sent a invitation to the County of Alameda to defend its moratorium, and they declined to do so. So she issued the summons, And there was some speculation that the county did not want to have that issue decided in the event that they were going to come up on the short end of it, and then they would be precluded from future applications of this emergency power. So for all intents and purposes, those of us who do this believe that cities, cities that didn't have their own moratorium were allowed to proceed without regard to the Alameda County moratorium. Hadn't had a chance to really test that because somewhat shortly thereafter, this was probably fall of last year, the Alameda County supervisors were coming under a great deal of pressure. I mean, should have been the same for a year and a half because the moratorium had outlived its practical usefulness a long time ago, in my opinion. And finally, in February, they kept, Board of Supervisors kept pushing the hearings away, and then finally on February 28th, and maybe it had something to do with a Channel 7 or a Fox News, some published news report of people outside the supervisor chambers, with signs saying, "Look, they owe me. Tenant lives here and owes me $90,000, and meanwhile they're renting their house and living in my house." I mean, they just a lot of little horror stories. And so, on that February 28th meeting, the Alameda supervisors declared the end of the moratorium and emergency. But the way the language of the moratorium was structured, it ended 60 days after that action was taken. Excuse me. So, effective April 29th, the Alameda County moratorium expired for basically all purposes. Now, it had some residual effects, which we'll talk about a little bit later. But basically, as of April 29th, the restrictions in Alameda County, whether it applied to the cities or not, expired in terms of the ability of a property owner in Alameda County to now pursue normal landlord-tenant legal efforts. If the tenant's breaching the lease or hasn't paid the rent, or if the owner wants to move in, all the things that had been prevented for almost exactly 3 years. So now for cities that have their remaining ones, or cities that continued their moratorium, which we're going to talk about, then that's a different story. So just looking at the PowerPoint presentation, after basically April 30th, you're free to go, free to proceed. Now in Alameda County, and this is also going to come up a little bit later, the tenants with unpaid rents that accumulated during the moratorium could not be subject to eviction for those unpaid rents. Landlords could pursue them in small claim or any collection action. Part of the state law. So in August, just again, a little background, in August of 2020, California legislatures passed AB 3088, which was its initial effort to sort of bring some order to the chaos that was all of the local jurisdictions legislating their own efforts to address the pandemic specifically in terms of landlord-tenant relationship. So AB 3088 did a variety of things. But one of the things it did was it adjusted or amended the small claims statutes to allow for an unlimited number of claims, which I think typically is limited to 2 a year by the same plan, and it eliminated the cap on the amount of damages that could be sought, which previously was $10,000, and now for unpaid for COVID-related debt, which is defined as rent that came due between March of 2020 and September 30th of 2021. These dates have started to fade a little bit. There was no cap on the amount that you could seek as a landlord in small claims. And everybody knows small claims is the preferred route for certain matters, avoids lawyers. It's much faster. So it was, I think, a good move. So in Alameda County, that is the state there. So moving on, cities. Berkeley, I'm just going to sort of read from here, but basically in March of this year, Berkeley City Council amended its ordinance to provide for the eviction moratorium to phase out. And the first phase, called covered period, and it was going to begin May 1st, and it would go through August 31st. Pardon me. The covered period expired April 30th, and only all it really added was said that owners could do an owner move-in. Previously, just like Alameda County and Oakland and most of the other moratoriums, it allowed evictions only for public health and safety concerns. But this phase one that began April 1st allowed owners to do owner move-ins finally. And that was qualified in the sense that you can only own one unit in Berkeley. So basically somebody who bought a single family home or a condo in February of 2020 who had been prevented from doing an owner move-in since could now proceed. So that was, a pretty modest change. And so the second phase, the transition period, is from May 1st through August 31st. And in that period, which we're in, evictions are permitted, again, for the public health and safety exception, for the owner move-in with only one residential property, or for non-payment of rent that became due as of May 1st, unless the tenant can provide a COVID-related defense, basically. So you can serve 3-day notices demanding the rent that came due after May 1st, but the tenant can, if the tenant can establish that they can't pay because of COVID, then that'll be defense. How many people are going to qualify for that? Obviously employment is, record lows and so on. So it's hard to imagine somebody claiming they can't get a job because of COVID. Maybe long COVID, health effects. I don't know. I haven't had a chance to try one yet. So, I'm sure tenants and their attorneys will get creative, but so that'll be interesting to see. Oakland. So Oakland in March. I actually had this up, but because I have Zoom and this PowerPoint, I'm not sure I'm going to find it without losing that stuff. But basically, the Oakland City Council issued an amendment to its moratorium, and it basically said as of July 14th, it terminates. It says July 15th, but I think it's July 14th, but either way. After that, there are no restrictions in Oakland for landlord-tenant legal actions. So it's basically back to pre-COVID days. Now, it talks about if tenant was unable to pay the rent between March of 2020 and July 14th. I had a staff member write this, which was true. Tenants could never be evicted for that unpaid rent, just like the Alameda County version. However, the amendment that the Oakland City Council passed removed that provision and basically put in a provision that says the tenant can't be evicted if they can establish a COVID-related reason for not paying the rent. Now, caveat, in contrast, the Alameda County moratorium said that there cannot be evictions for non-payment rent for rent unpaid during that period of time. So it's unclear if the Alameda County moratorium, which says no evictions for unpaid rent that accrued during the COVID era, will supersede Oakland's revised ordinance. And I don't know. We just talked about the idea that the Alameda City challenged the county's application to cities, and the Alameda County moratorium did say that if the local jurisdiction had a stronger protection, it would apply. So I don't know. That one somebody's going to test, and some judge will make a decision. Probably 3 different judges could make 2 different decisions, and then somebody will appeal it. I don't know. But that's the issue. You can go back, according to the Oakland amended ordinance, you can seek unpaid rent that accrued prior to July 14th, but the tenant can defend based on showing that they couldn't pay the rent. Now, San Francisco has I'm just going to jump over to San Francisco for a moment, has an ordinance that is in effect. Well, it was in effect from July of last year, and it's unclear because it was supposed to terminate when the mayor's state of emergency was declared over, which has happened. But during the period from July until at least February of this year, the tenant could defend a non-payment of rent case by showing a COVID-related reason for not paying the rent. And so it occurred to me that serving a notice that listed several months, which I'd done in one case, could be defeated by the tenant simply showing that they were unable to pay one of those months' rent because of COVID. So in response, I have now a new matter, a new strategy to serve a notice for each month and then serve them all together. And then each notice becomes a cause of action and unlawful detainer. And the tenant will then have to defend each month if they want to establish COVID-related defense. And yeah, I don't know. We'll see how that goes. That's underway literally as I speak. So in Oakland, after July 15th, rent that becomes due now, rent that becomes due July 1st, which is most rental agreements from first of the month, it is immune from this. But if you have a tenancy where the rent starts on July 15th, that can be a 3-day notice if they don't pay it. And then after that, obviously August 1st and so on. And then you have still the tenant obviously the rent was not waived. The landlord can still try to collect unpaid rent that accrued during the COVID era. But as I mentioned above, there's no restriction on that. The original Oakland moratorium gave tenants 12 months after the expiration of the state of emergency to pay unpaid rent. But that provision appears to have been removed from the current amended ordinance. So there does not seem to be any restriction under Oakland's ordinance on seeking unpaid rent through the collection process. Now, Alameda County's ordinance, again, sort of another caveat, limited the demand of unpaid rent to rent that was owed for at least a year. So, for example, rent that came due in May of last year you could now seek it, but rent that was due after that you could not under the Alameda County ordinance. Again, whether it will supersede the Oakland ordinance, it's just the same issue as the 3-day notice issue talked about above. So, again, people will proceed and judges will make decisions, and then we'll all learn. The San Leandro, has for whatever reason, and I'm just going to go with this. February 21st, the City Council approved an ordinance extending their moratorium for 1 year until February 20th, 2024. And this is the only one I know of in the Bay Area that extends beyond the existing ones that we're talking about. So it's the only one that's new, so to speak. It basically just is a 3-day. I mean, it allows the tenant to defend the non-payment of rent case by showing they can't pay due to documented COVID-19 reasons. Now, a lot of these ordinances, which were thrown together in haste and not revised, basically just said the tenant could just say, "I can't pay," and that would be enough that as a defense. The declaration that was required under the state law was just basically that. So this one makes it a little tougher. It says the tenant has 30 days after the date the rent is due to provide written notification to the landlord that they cannot pay the rent and documentation to support it. Now there's a list of the documentation, and the city provides a form for the tenants to use. So anybody who's going to have a client or a case in San Leandro needs to review that ordinance and obviously comply. And I think there's a provision where the landlord, for whatever reason, has to notify the city within 5 days of having gotten this notification from the tenant. Whether that would be a defense if the landlord fails to do so or not clear. As most of you know, if you're in one of the jurisdictions like Oakland or Berkeley or San Francisco and you fail to submit a copy of your notice to the rent board when it's required, that is a defense to the unlawful detainer. So I didn't see that in this one, but I didn't read the entire ordinance, I admit. So anybody who's going to take a case in San Leandro wants to become familiar with that issue. But again, a much more limited opportunity for the tenant to defend. So, all right, changes to the landlord-tenant relationship and eviction process that will continue past other than San Leandro. So in Oakland's amended ordinance that was passed in March that I just mentioned, in addition to revising the eviction moratorium, they added a limitation to the just cause ground under Measure EE for non-payment of rent, which basically said that the landlord cannot proceed until the tenant owes at least a month, the value of 1 month of fair market rent as determined by the HUD's guidelines, and they're out there somewhere. I probably should have a little slide there, but unfortunately I don't see it from my staff member inserted, but it should be reasonably easily found. But basically, as you all know, if you have a tenant who's been in a unit for quite a number of years, subject to rent control, their rent is usually significantly below market. So if you have a tenant that's paying $1,000 for a 1-bedroom in Oakland, and the HUD fair rental value for that unit is $2,000, which is not unlikely, then if the tenant falls 1 month behind, you cannot serve a 3-day notice. You have to wait until at least 2 months, or as many as it takes, but before what they owe is equal to the fair rental value for 1 month. So something to be aware of. And so this is the ex parte application for those of you who practice. In order, as I mentioned earlier about the city of Alameda's dispute with the Alameda County Superior Court, Rule 1.81 is a rule of court, and it's an emergency rule promulgated by the court itself that said the court may not issue a summons for an unlawful detainer unless it comes with these things: a declaration stating the health and safety related necessity or other exception, which would basically be the Ellis Act, an order permitting the filing, proposed order, and then it's an ex parte application, so all available contact and so on. And then you submit that, and my staff has struggled with this. I thought everything got submitted at the same time. You file your summons, your complaint, your ex parte application, but I've been told no. You file your summons and complaint and get a number, a case number, and the court will not issue the summons, but they'll give you a case number, and then you submit your ex parte application for an order issuing the summons. And all of that takes time. I mean, it was taking anywhere from 2 to 4 weeks, maybe more. So quite cumbersome. But there are attorneys that are on sort of an informal working group with the Alameda Superior Court, both tenant and landlord attorneys, and I get little updates from them. And if you're out there, you know who you are. And it's clear Judge Kolakowski understands that with the expiration of the Alameda County moratorium and the pending expiration of the Berkeley and Oakland moratoriums, that this rule is no longer needed, but she doesn't have the power to change it. So the wheels are turning in Alameda Superior Court with whatever group of persons in that entity that are required to make a change to the rule. So we all expect that will expire, or there will be an order ending this particular rule like any day now, basically. But until that notice is issued, until that rule is revoked, you still have to submit your ex parte application. But in our recent experience, they're going much faster. I think the court is just rubber stamping. I mean, it's just like, okay, boom, summons issued. So, but again, still got to go through the hoops. Oops, let's go back. Did I go? Can landlords collect back rent? Yeah, forms of assistance. Well, I can answer that one. I'm not aware of any. The state, the emergency rental assistance program ended as of March of last year. Under the state's rent reimbursement program, which was contained in a couple of the iterations of the, AB 3088 was the first state law that tried to address all the COVID dysfunction. And it did not have any provision for state assistance. And then in January of 2021, SB 91, and I used to know these, but I'm pretty sure, SB 91 was passed because AB 3088 was going to expire at the end of January, and its protections with regard to the tenant if they filed a declaration and paid 25% of the rent and so on, if you remember those things. So SB 91 not only extended those rules through, I think, June of 2021, but it created a landlord repayment plan. And so the state funded a big pot of money to pay landlords under a website application process that both, I think, landlords and tenants had to cooperate in, and that was some issue. But it only paid the landlords 80% of the rent that was unpaid, and they would only get that if they agreed to waive the remaining 20%. So, it was a start, but a lot of landlords obviously were not happy with it. And so in March of that year, I think it was AB, now I've lost track of which number that was, but it revised the program to basically promise, and I think for the most part, it performed, to pay landlords 100% of the unpaid rent that the tenants couldn't pay as a result of COVID. And so that program went until March of 2022, when it ended applications for the rental assistance. But part of that program also included that certain jurisdictions, basically those with more than 200,000 people, whether it be city or county, could administer their own programs, and the county would just give them block grants to do that. And I think Alameda County did that. I know Oakland did that. And so they had a different emergency rental assistance program, ERAP. And it was going on after the state terminated or concluded. So I'm not 100% sure if any money is left, if they're still accepting applications. I wish I could give you a little more guidance on that, but I just don't know. All right, so as far as collecting unpaid rent, so one of the other things the state law did, which said no matter what a local jurisdiction tries to do, that any unpaid rent that accrued during the COVID period, if it's not paid by August 31st, 2023, is subject to collection, meaning cities could delay tenants' obligation to repay rent at least as far as August 31st, 2023. And after that, no local rule could protect tenants from at least collection actions. So that's really, sort of no matter what else we see here today, I think the August 31st, 2023 state end date, after that, it's basically no holds barred in terms of trying to go after tenants for unpaid rent through the collection process, whether you do a superior court action or a small claims action. But in the meantime, Berkeley has its provision that basically breaks it down into a couple of different periods. And at this point, you can read this: rent that accrued through January 31st, tenants had until March 31st, 2022. Otherwise, the landlord could proceed with a collection action for rent that accrued after February 1st. They had until July 31st. They have until July 31st. If they can again show, they have to show this covered reason for delayed payment. So that is Berkeley, and you can't charge late fees or interest, or that's basically it, late fee for any rent that was not paid for a covered reason. I see I get a sign that says somebody wants to admit. I'm not sure if I'm supposed to push that button, but all right, just one way. Oakland's repayment guide. Basically, I think it's after July 14th. It's you can proceed. There's no restriction in the Oakland ordinance on seeking unpaid rent, either certainly by collection actions. So again, as I discussed above with regard to seeking unpaid rent through the non-payment process, through the 3-day notice process, Oakland's new ordinance allows that, but the tenant can defend by showing a COVID-related reason. So same thing for the effort to collect rent during that period of time through the collection action. Now, again, the Alameda County version, which gave the tenant 12 months to repay any unpaid rent, may collide with the Oakland version. So as I mentioned earlier, we're not really sure how that's going to play out. And you can't, if tenant pays rent now, you can't apply it to old rent. That's pretty clear. Any rules for Hayward? No, nothing that I've seen. So as far as I know, you're free to proceed in Hayward. now that the Alameda County restrictions have lifted. So yeah. And let's see, did I see another thing? Okay, here's from Krista. Oakland is new tenant protection will not allow to serve a 3-day and move to UD until the tenant is 1 month of unpaid of an equivalent unit. Right. Well, I think I covered that, but thank you. Robert, no, this does not apply to commercial tenancies. This is all limited to residential tenancies. There were commercial protections, but they've all expired. And then maybe we receive a copy. Sure. And that's for, okay, so I'm down. Okay, if a tenant pays rent but is causing a nuisance, is that grounds? Sure. I mean, well, again, while the moratoriums were in effect, the exception was for public health and safety. Now that, was never defined beyond that. And so it was kind of like the Justice Powell pornography thing. I know it when I see it. You just had to make a call and think, is this enough to, be a public health and safety issue? Nuisance, trespassing. Yeah, I mean, you could, submit it and see what the judge does with it. But, it needs to be obviously a good faith, it's got to pass the laugh out loud test, right? Well, they still teach that in law school. Can you discuss process for Alameda City court changes, Alameda County court changes that, well, again, so yeah, I understand this is from somebody, Randall Whitney, who probably knows more about this than I do. Yeah, the Judicial Council, I don't know if it has to be ratified by the state Judicial Council. My understanding is that there is an Alameda County Superior Court procedure that allowed them to create this. They had to have authority from state statute, which Governor Newsom's emergency legislation provided. And so when the expiration of his state of the California state of emergency, you would have thought that would have just undermined their ability to even have this rule. But again, I'll let somebody else figure that out. I just follow the rules that I see in front of me. So, but yeah, I believe that that change to 1.81 is imminent. And it may be, like I said earlier, any day now, but we'll all find out eventually at some point. I will say I had a summary judgment on a commercial case in 511 on Tuesday against a former attorney, and he submitted about 50 pages of opposition on Monday, and so the matter was called Tuesday morning, and he had listed a bunch of objections to our. I believe in certain unlawful detainer cases you can make a prima facie case for summary judgment because it's pretty easy. It's it's a relationship. The termination of the notice of the relationship by notice, service of the notice, continued possession, and that's it. That's your prima facie case. And so then it's up to the tenant, the defendant, to introduce admissible evidence that either creates a triable issue of one of those facts or presents evidence of a affirmative defense. And so being a commercial, basically somebody who kind of like a WeWork thing, guy rents an office in a set of suites, and the property the lessor was a master tenant. So my client was a master tenant of the spaces, rented 2 floors, let's just say, in an office building from the owner, and then sublet basically to businesses, individuals. In this case, like I say, a former attorney. And so subject to a service agreement. So service agreement gave the property owner, the master tenant, the right to terminate on either default grounds. In this case, guy wasn't paying the service fee, also known as the rent. But I was trying to follow the language of the agreement, and there was a little dispute about whether it was a license or a tenancy. And the whole issue about that, if you have exclusive possession, no matter what the document says. I mean. But that really wasn't a dispositive issue. So we like, all right, call it a tenancy if you want. We'll call it rent if you want. It doesn't make any difference because we serve proper notice, certainly under the provision of the agreement and in accordance with the CCP 1162. So he just threw a bunch of smoke and mirrors, and the judge was going to take it under submission. And I asked her if we could just go through his objections, because his evidence was really in inadmissible to create a triable issue of fact. All he could do was attack our evidence. And so we went through all of his objections. And his legal argument was that because my client wasn't the owner of the building, they couldn't proceed. Well, the statute says very clearly a master tenant can proceed on unlawful detainer. So that was easy. And then he said, well, they're renting suites in violation of business and profession codes 10031, which is basically the provisions that deal with real estate licensees and brokers, and requires a real estate license to do certain things related to property management. And so, and he'd done all this in a demur, because his first objection, his first defense effort was a demur. And the court, went through these arguments and said, yeah, it looks like, that statute only applies to agents acting for a third party. And in this case, this person, this entity is acting for itself. So he basically made the same arguments in the summary judgment and tried to, attack our submitted evidence. And she went through each objection, and he, for 5 or 6 bases for trying to exclude the declaration of my client, and she overruled him on each one, and said, all right, well, I think, is that anything else? Well, like, no. He's like, all right, well, I'm gonna grant the motion. I'm like, yay, because this guy would have he's already put my client through a tremendous amount of expense and challenge. And it's just the simplest thing in the world. It's a little room, it's a suite, he rents for $900 a month. And yet, because he has this legal background as an admitted attorney who's no longer, I think, allowed to practice, he's able to just jam the gears up, considerably. So, to hear that little sweet phrase, motion granted, did my client a great favor. So now I'm anticipating a bunch of other, shenanigans, but, that was a pretty big hurdle. Now, what does that have to do with the moratorium? Only an answer to the question, does it apply to the commercial space? And no, it doesn't. But it did, just hasn't for a while. So can you also talk about the 7A? Oh, okay. So yeah, this is a question from Emily. Can you also talk briefly about the 7-day notice to cease in Oakland? Somebody asked earlier, and I'll come back to Randall in a moment, but somebody had asked earlier, not here, but in a different way, if that 7-day notice applied to non-payment of rent notices, and it doesn't. So the 7-day notice to cease, for those of you who are familiar or not, was really a sort of what's the word I'm looking for? An innovation that I think was for the first time provided in Oakland. Well, I'm actually down here in LA taking care of my daughter's golden retriever. So if you hear a moaning sound, that's what you're hearing. I should get up and open the door in just a moment. But the ordinance was amended to require that before an owner could proceed with a 3-day notice, whether it be to cure or quit, or to quit under the sections that allow just a notice to quit, the owner had to serve what we began to call pre-notice notice, and this was the 7-day notice to cease. And there's regulations that kind of fleshed out a little bit. They actually have their own form of notice, and so yeah, if you didn't do that 7-day notice, you couldn't proceed with a 3-day notice. So that remains in place. One thing though, they do have, thankfully, an exception that if the tenant's violation is something that is akin to the public health and safety, provision in the moratorium, you can do a 24-hour notice to cease. Like if they're, being violent or destructive of equipment or property, whatever, 24-hour notice, boom, and then you can start with your 3-day notice. So, so there you have it. So I'm going to go back to Randall, and how does 60-day notice differentiate from 3-day notice, since most of the restrictions are against 3-day notice, meaning if we file a 60-day notice, terminate lease, then they have to serve immediate if 3-day notices are restricted. Well, to terminate a tenancy, can be done on different reasons. And in all of the just cause provisions, the things that the tenant has done wrong are generally, the cause for 3-day notices: non-payment of rent, breaching the lease by having a subtenant when they're not allowed to, or a pet when they're not allowed to. Of course, they can say it's a comfort animal, or the ordinance allows me to, replace my tenant on all of that. But still, those were 3-day notices. Terminating a tenancy based on something that the landlord was doing, like an owner move-in or an Ellis Act, or removing the unit for, rehabilitation or substantial improvement, those required the 30 or 60-day notice. 30 if the tenant's been there less than a year, 60 if they've been there more than a year. So that's the distinction there. It really wasn't on the type of notice, it was on the basis of the notice. And so the moratoriums all prevented all of the notices except for 3-day notices based on public health and safety. Now, that's interesting. I think, yeah, we had a couple in Oakland, which were public health and safety, and we would go with the 24-hour pre-notice notice. Because in a couple of cases I had, the tenant was really, threatening other tenants or, really, really tearing up the place. So hope that answers that question. Now, once the moratorium, just to conclude, once the moratoriums have lifted, you're back to the land before. So you can serve a 30-day notice to terminate it if you want to do an owner move-in, unless the tenant's been there more than a year. And these are all, for local rent control provision or tenancies. Statewide has its own just cause now for tenants who've been there more than a year. That's a distinction that is probably worth noting. And there's actually a state an amendment to the state statute that's in progress right now. I forget the name of SB 8657. I can't recall it right now. That wants to provide the tenant with the just cause protections of state law immediately upon taking occupancy, which is what most of the local ordinances do. Once you're a tenant, you're subject to the provisions of the ordinance. Some of them have other one-year provisions, like if you are going to do an owner move-in and the tenant has been there less than a year, you don't have to pay them relocation benefits. But you still have to have a just cause and go through the procedure. You just don't have to pay relocation benefits. So there's still even some local things where a year period makes a difference. But under the state, I will just call it eviction control law, AB 1482 is that particular ordinance. I think the Tenant Protection Act. The tenant had to be there at least a year to qualify for those protections. But again, there's a move afoot in the legislature, and it's moving through. It just moved through committee. And I'm not an expert on legislative, procedures, but it just went through the committee that it had to get through, and then it'll go to the floor for a vote. That whole thing. So it may be that when next time when you wake up, your tenants who are not subject to local rent control will be subject to state control as soon as they take occupancy. Because for I think a lot of people subject to the state law, that was a kind of a nice thing. It's like, okay, here's a 1-year tenancy, and I get a chance to evaluate them. But if they're just not working out, they're late on rent, or they bother the neighbors, or they just don't keep the place, garbage, whatever. I'm not going to renew the tenancy, and I have the right to do that. So that right will, if this new legislation passes, that right will no longer apply. So does any of this impact what you should do if you find 300 Air Jordans in an abandoned rental? I don't know if that's 150 pairs or 300 pairs. You might want to know. It doesn't matter. The rule about abandoned property is you have to, if the tenant was evicted by the sheriff, meaning through a writ of possession, the sheriff's eviction notice to the tenant will actually provide the notice of right to reclaim abandoned property, so the owner doesn't have to. And the former tenant has 15 days, to go through the procedure of removing their stuff in coordination with the property owner. But if the tenant just vacated for one reason or another, and there wasn't a stipulation that they waived the right to recover abandoned property, then you have to serve a notice of right to reclaim abandoned property. And you mail it, and they have 18 days. They're responsible for the fair rental, not the fair rental value, but the storage value, which is usually the fair rental value if you leave it in the property. But if they then do not collect their stuff and it's worth more than $700, you have to auction it off. So if you find yourself the owner of 300 pairs of Air Jordans, I guess you have an auction and nobody shows up, then you can bid and then you can sell them on eBay. Okay. Let's see, 2 new messages. I don't think this question was answered. What do you know about proceeding in small claims and some of the challenges there? Well, I tried to and please discuss preemption. Well, that's and also the Williams case involving which challenged him. Well, so there were a couple of cases brought in to challenge the moratorium. There was one in federal court, two, one against the county of Alameda and one against the city of Oakland. And I think that was the Williams case. And in September, the plaintiffs in that case, which were, basically a bunch of property owners, with horror stories about, not being able to collect the rent or move in to their own homes and so on. And they had moved for summary judgment, and the magistrate in the federal court, denied summary judgment. So that case was set for trial. I don't know. I guess it'll go because, they're doing a takings clause and a damages claim. So that will probably continue. Whether there will be a finding at that point as to whether the Oakland ordinance was unconstitutional as an unconstitutional taking or exceeded the police powers. Again, it was slightly above my. If I had the time to really study it, I think it'd be very interesting. But I just sort of read the highlights. So that was that case. It was the Alameda City case that was just seeking an order that the Alameda County moratorium could not apply in incorporated jurisdictions. And that was really not a taking claim. It wasn't a damages claim. It was just a sort of a level of government. Can the county legislate inside our city? So I think that probably got this. Well, as I said earlier, the court punted back to Department 511 and said, you decide whether the county moratorium can apply to the city of Alameda. And when the county of Alameda failed to defend its own ordinance, Judge Kolakowski I don't know that she did rule. She said, they failed to defend, so I'm going to grant the order, and I'm going to issue the summons. I don't know how much deeper she went into the legal rationale, or just basically saying, since the county did not defend its position, I'm going to grant the application. So that was that. I didn't really know the deep law between counties and cities. We all know the preemption at state law. If it fills the field, cities are preempted from legislating within it. And that's, again, those areas are so, like, the unlawful detainer statutes by state law, gives the landlord the right to proceed on these basic grounds. But then local jurisdictions changed that and said, no, you can't. Tenancy terminates. That's under state law basis to remove an unlawful detainer. But no, we're not. And then the Birkenfeld versus City of Berkeley case, which I think 1972, which went, I think, to the U.S. Supreme Court, addressed that in detail, and they concluded that yes, cities had the authority, presumably counties as well, to provide these eviction. And they made the distinction between substantive protections and procedural protections. Cities and counties cannot put procedural protections in place because that is where the state fills the field. But they can put substantive protections in. I never really understood, I'll be honest. But that's how it broke down. And all the local ordinances that try to affect the landlord's right to move against tenants get analyzed under that procedural versus substantive basis. So hopefully that addressed the preemption issue. And I think as far as Emily and the small claims, basically, bright line, after August 31st, all the unpaid rent that was owed by a tenant can be sought by a collection case. That's the bright line, and that's based on the state law. Within local jurisdictions, that may come sooner, or it may be contested. In a way, I just tell clients, just go ahead, proceed. If you think you have a reasonable argument that the local ordinance either has expired, and you can go forward and let the other side defend it. So that's my position. Let's see any further. What are the chances that the conservative? What are the chances that the conservative majority in the U.S. Supreme Court invalidate these eviction moratoria as regulatory change? I would say good, because that's kind of how the political landscape shakes out. Yeah, that would be interesting. It's a good question, and thanks for raising it. Obviously we won't know the answer, but certainly you can make your own predictions. And then Christine, can landlord evict for unpaid rent for February 2020 before the moratorium? Well, so this is something that didn't come up. So one of the things the state law did was also extend. So as those of you who do unlawful detainer, litigation probably know, a 3-day notice is limited to only the last 12 months of rent. So if you wait 14 months for somebody, who's been and then decide to move, you can only do a 3-day notice for the last 12. So that's really very straight, bright line, black letter, unlawful detainer statute law. But the state ordinances the state laws that affected all of these things had another provision in addition to the ones about like expanding the small claims jurisdiction and amount in dispute. Also said that to the extent any landlord was prevented from bringing a 3-day notice during the moratorium, that the 12-month period is extended to encapsulate, so you can go back 24 months if your facts line up. But rent before February 2020 is just a collection case, and if you don't hurry, you're probably going to get a statute of limitations at some point. Although probably all that stuff will be abated too. I mean, there's a lot of weird issues that are going to get resolved down the road. Statute of limitations for a cause of action for non-payment of rent extended because you couldn't proceed during the moratorium. Should be like being in prison or some of those other reasons for abating the statute of limitations. So yes, you cannot evict for unpaid rent for February because there's no way your 3-day notice can go back that far. I see suit was filed February 20, but suspended. Well, yeah, I think you just got to bring your application to the court to renew that case because all of the ordinances provided that it didn't apply. Well, I think we're out of time on that one, but I would just bring my application to the court and say, I'd like to set this for trial. If you have a pending unlawful detainer that was for February 2020, claims, I think I would just have set for trial, do your memo to set for trial, see what happens. So, thank you everyone, and appreciate the remaining, participants, and hopefully that CLE will be just enough to put you over the edge when that 3-year period comes around.